My talk is a little bit less detailed. My talk is more practical than it is case by case. There are some very wide, broad subjects that I intend to cover, and I think I'm going to try and do it in an interesting way. And it's interesting that I was able to hear the bulk of the previous lecture, because when I was sort of growing up in this business, the one thing that criminal lawyers, litigators feared was tape-recorded evidence, and it still is a pretty big part of most prosecutions involve tape-recorded evidence. Today, more than tape-recorded evidence, the electronic evidence, quite frankly, causes much more difficulty. I haven't been in a really good white-collar criminal case in the last 10 years where the most damaging evidence was not either an email or a text message or a record that was retained on a computer. So let me just give you a couple of observations from my perspective that sort of dovetails with what you just heard and blends in and leads into my topic. Know a couple of things. You can never erase an email. I don't care how good you are and how savvy you are and what kind of tech skills you have. It's always out there. It's somewhere out there, and it can be restored. I've had clients take computers and throw them in the ocean, thinking that works. You never know who your email was forwarded to, so you have no way of tracking it. Second, however well you try and erase it, it gets restored. Most people who try and erase their emails end up erasing the ones that are helpful and the ones that are bad, and they end up in an obstruction of justice if, in fact, subpoenas have gone out. So don't try. It doesn't work. One thing that was mentioned just a minute ago, a lawyer who engages in deception violates a very serious ethical consideration of the New York State Bar. So if you were to go on a web page and pose as someone else's high school friend in order to access their Facebook page, you can get disbarred in New York for that. So that's two. Second, unlawfully accessing someone else's private email is a crime under New York State law, and it's a crime under federal law. So this is sort of like much more complicated from my perspective than simply to say it's good to check this stuff out. You know what the biggest problem we have now? Jurors are, while they're on cases, are Googling the players and are researching the issues. And if you have spent 3 weeks or months or years convincing a judge to keep out someone's prior criminal record, jurors go on to Google, find out who the person is, know more than anyone else about it. And studies have been done where jurors who've been excused have been questioned, and basically all of them, they're afraid to say it, but all of them either think about doing it or actually do it while they're on trial. So it's something that we're getting very, very, very concerned about, certainly in the criminal defense bar. So let me talk about tape recordings, but let me just tell you why an email and a tape recording is very much the same, but an email is in many ways worse. We text like we talk. We don't even think about what we're doing. I look at some of the emails sent out by people who work for me, and I almost have a heart attack that someone would say that. And when you say something in jest on a tape, it sounds like you're kidding. When you say it in an email, it's hard copy, black and white. There is no tenor. There is no inflection. There is no explanation point often. Sometimes you leave off the punctuation. So asking a question, if you don't put the question mark, sounds like a statement of fact. Saying something nasty about someone that you would hope would never, ever get repeated is there forever. And while tapes are rare, emails are not. So the average person in this room is never going to find themselves having been surreptitiously recorded. But everybody here texts all day long. Hopefully not when you're driving, but texts all day long. I passed someone today who was texting, applying eye makeup, and drinking a Starbucks while they were driving at 45 miles an hour on the Belt Parkway. That happens everywhere. But texting becomes automatic, and we don't think about it. And what our kids say is scary, what young people say, what professionals say. And the emails always arrive later, and if they're taken out of context or you didn't mean it. So let's talk about my topic, tape recording. There isn't a really good criminal case that the government has made in the last 20 years that doesn't involve some type of electronic evidence. It's simply the way it is. Things don't get solved by people pounding pavement. They get solved by either getting a wiretap and listening into private conversations, or they have a consent recording where someone who is either a criminal or an active participant agrees to record their conversation. And the reason it's called a consent recording is because under the law in New York State, if I am a party to a conversation, I have a right to record you without you knowing and without getting court approval. I can wear